Welcome to Civics in a Year, the podcast that makes civic literacy fast, accessible, and surprisingly engaging. In just 10 minutes an episode, we'll tackle one of 250 essential questions about American democracy, how it works, why it matters, and what it means for you. Whether you're a student, a teacher, or just someone who wants to better understand your country and your rights, you're in the right place. Civics in a Year is powered by the Civic Literacy Curriculum from the Center for American Civics and is produced in partnership with the School of Civic and Economic Thought and Leadership at Arizona State University. Welcome back to Civics in a Year. We have Dr. Sean Bienbird back with us. At this point, we should just call it the Liz and Dr. Bienbird podcast. But yesterday, we talked about Abraham Lincoln in this first inaugural address. And today we're actually talking about Abraham Lincoln and his habeas corpus message. So, Dr. Bienbird, the suspension of habeas corpus is actually listed in Article 1, Section 9
Yep.
of the U.S. Constitution. Can you first, for our listeners, what is habeas corpus and what does it mean to suspend it?
Yep, I was going to start with that. So habeas corpus is an old-timey British legal writ that effectively is challenging an illegal detention. So it's again, habeas corpus isn't saying I'm innocent. It's saying, there's no the procedures haven't been followed or something like my detention is illegal, and so. This is a traditional part of English liberty, basically challenge an unjust detention. Like the executive or the king can't just throw you away in jail. You'd say, no, I need to be charged with X. You need to have, protocols. So habeas corpus is basically an old-timey protection against arbitrary and unjust detention. Obviously, this causes a problem because if you are in wartime and you potentially need to suspend civil liberties, you're not going to be going through and, here's our Fifth Amendment protocols for arresting traitors, you're going to have to. And so the ability to suspend habeas corpus goes back into English history, but it was a privilege to Parliament. And so the wrinkle here is that as the Civil War is spooling up again, Congress isn't in session. And so Lincoln suspends habeas corpus before Congress has met. And he argues that he has the authority to do it because the language just says habeas corpus shall not be suspended. This is why students don't write in the passive voice, because it doesn't say Congress shall not suspend habeas corpus or the president shall not suspend habeas corpus or no one in the federal government shall suspend habeas corpus. It just says it shall not be suspended. It occurs in Article 1, which generally is the congressional constraints. And so there is an argument, pretty good one, probably even the right one, that this is a prerogative that is supposed to be attached to Congress. You certainly wouldn't let the monarch suspend habeas corpus back in the day, but Lincoln and Bates argue. Bates is his attorney general who releases a memo explaining it. But there is a solution if you think that the executive has wrongly suspended habeas corpus. You can either impeach or vote him out next time. So they think that it's actually sort of by design and appropriate that it's agnostic as to who gets to suspend habeas corpus. The more others take the argument to say, no, in the British tradition, it needed to be Parliament. It's in Article 1, it needs to be Congress. Now, again, it's worth noting Lincoln's suspension of habeas corpus is originally pretty limited. It's limited geographically. And in fact, there's a set of follow-up messages he gives to Winfield Scott, who's the commanding general, who'd been a hero of older wars, right? He's not he's too old to be like a field commander anymore, but he's still basically in DC. And he basically says, stop doing habeas corpus suspensions unless necessary, constrain it to this particular part. They're really trying to protect basically Maryland. They're concerned that if basically secessionists take control of the Maryland government, Washington, D.C. will be surrounded. Very legitimate concern. So it's not just simply a general suspension everywhere in the United States during the war. It's geographically limited. Later on, it will be geographically expanded, but limited to certain particular sets of acts. So again, Lincoln is, to his mind, and he writes lots of letters explaining this, trying to basically say, like, look, this is an actual power in the Constitution. Clearly, this is supposed to exist. Clearly, this is the kind of moment when it's supposed to happen. And then he gives what I think is one of the best, his July 4th message when Congress finally does convene. And he walks through and explains his constitutional reasoning. And he makes, again, a decent case constitutionally. But he says he will ultimately, if Congress says no, like this is wrong, he will defer to that. And he very famously says, are all the laws but one to go unexecuted, that basically that they should all fail, right? He says effectively, look, some people have said that you might need to break a law to defend the rest of the Constitution. And, here's a tough case because the Constitution is failing. This is something he talks about in the first inaugural address that I forgot to mention. But, he says, I have a constitutional oath to execute the laws. And that means in the southern states because they're real states still. He doesn't accept secession. And so in this one, he says, well, what if my choice is between suspending habeas corpus illegally and the whole Constitution failing? But then Lincoln goes on to say, but happily, we don't have to worry about that because here's my pretty good legal argument for why I'm in the right. And if I'm not in the right, then Congress can stop me. So the July 4th message is a really, really sophisticated, I think, and thoughtful, but defense of the importance of the Constitution. I mean, even when he says, like, I don't think I had to break it illegally, but even if I did, the only justification for breaking it illegally is because literally the entire rest of the Constitution would fall apart. He's not saying I'm breaking it because it's convenient. I'm breaking it because it's my policy game. It advances some policy aim. But he's very adamant, says, as a piece of rhetoric, sort of the way he moves between the arguments is really impressive because he starts with this, do you really want the whole Constitution to fall apart? And you're like, oh, no, that sounds pretty bad. But then he says, but kids, don't worry. I didn't have to do that because the Constitution explicitly says habeas corpus can be suspended, and it explicitly doesn't say only Congress. But I will defer to Congress in this one. And Congress, of course, it's like, of course you did the right thing. You did the right thing, and it's retroactively approved. You're good. So yeah, the Lincoln, again, I had a brief period in college where I was one of the, like, Lincoln is a tyrant, and he abused the Constitution things. And in my, I'm not going to say wise years, but wiser years, I have become very deeply impressed by Lincoln's constitutionalism. I think probably on the merits, Tawney is someone who has mixed views. He might be right on this one, but it's to me like a 55-45 issue where it's not bad faith reasoning that Lincoln's just trying to torture something out. Like, it's a pretty good argument that they have to make. Tawney's might be marginally better, but Lincoln very much is trying to work within the constitutional system, again, faithfully, not just torture a pretext out.
And at this point, the Civil War is raging, right? Because this is 1863.
The suspension of habeas corpus begins in 61.
61, okay.
So 63 is when he sort of is when they start sort of expanding it out and generalizing it in later years. So 61 is originally just the tailored one. I'm trying to remember exactly what the scope of it is. I think it's between Washington and Maryland and Philadelphia and Washington, D.C. It's basically along what would be like the modern I-95 corridor, Acela corridor, but pretty much just trying to make sure Maryland doesn't get sort of captured by saboteurs to then push the legislature to secede. But later on, again, he changes it from the geographic basis to the like spies and saboteurs and a few other, like, you don't need to have habeas corpus in like hanging a spy or whatever, right? Mm-hmm. So it's 61, early 61, almost immediately after he takes office, does he originally do the suspension narrowly, and then he even within that one, he tapers it back and says, all right, like, cut it to this piece, cut it even to that smaller piece. And then to Winfield Scott in May 1861, he says, unless the necessity for these arbitrary arrests is manifest and urgent, they should cease. So if you're going to do this, do it very, very, very sparingly.
And this is considered a War Powers Act, essentially, right? Like, because America is in the Civil War, there are parts of the Constitution like this that can be suspended.
So the exact language is in Article. So there's the exact language. Article 1, Section 9 is the privilege of the writ of habeas corpus shall not be suspended unless in cases of rebellion or invasion, the public safety may require it. So it is not a freestanding, like, there are war powers and the president can do what he wants kind of thing. Like, it is an explicit power that the Constitution allows and also describes when it can be used. Rebellion or invasion and public safety. So it basically, rebellion or invasion is criteria 1 and public safety. So just because there's a rebellion somewhere doesn't mean that you can, suspend habeas corpus just willy-nilly.
So why would this, suspension of habeas corpus still matter today? Why is this something that we should be studying?
I mean, habeas corpus issues, they really animate the Supreme Court for a few years in the early 2000s, during the war on, Islamic radical terror after the attack on the World Trade Center and the other places. So, what do you do with somebody domestically who is, trying to set up a bomb or something like that, right? So they have, when can they suspend habeas corpus? Do people who are detained in Guantanamo Bay get access to the habeas corpus? So, it's a big constitutional issue because, for a very good reason, Americans cherish our constitutional civil liberties and access to court systems and such. But you also recognize that the Constitution in and of itself, again, no loose, expansive interpretations, it has a protocol for doing this under limited circumstances. So, yeah, habeas corpus is a big deal because it is eliminating it is suspending core constitutional liberties, which is not something that you do lightly, but it is something that may need to be done under certain circumstances. So, again, as with many things, I sort of wish the constitutional folks hadn't done the passive voice, but the basic idea of habeas corpus is a guarantee. But there's a recognition you need to suspend it is basically I think the founders doing generally a pretty good job on that.
Dr. Bienbird, thank you so much for this, legal history and looking through. I know we did Gideon versus Wainwright for one of our Supreme Court cases, talking about a habeas corpus petition. And it looks like the most recent Supreme Court case was in 2026. So this clearly is still something that is, being looked at by the courts, being looked at in laws. So thank you very much.
Thanks for joining us on another episode of Civics in a Year. If you enjoyed this episode, be sure to subscribe and share it with someone who cares about a constitutional republic as much as you do. For more episodes, resources, and updates, follow us on social media or visit us at civics.asu.edu. Make sure to check out the show notes for any relevant links. Special thanks to the United States Marine Band for their performance of the Stars and Stripes Forever. Let's keep building a stronger constitutional republic, one episode at a time.